Welcome to our deep dive on the F-2 fallout after divorce, specifically when your dependent spouse has never entered the United States. In this video, we will walk through what changes the moment a divorce is finalized, what the F-1 student must do immediately to remain compliant, how SEVIS updates work, whether you should contact a U.S. consulate about revocation, and practical takeaways to protect your status. We will also provide a clear disclaimer and end with key action points and a short quiz to test your understanding. Let's begin. Here is our roadmap. First, we will cover the legal shift that happens at divorce. Next, we will discuss your mandatory SEVIS action. Then, we will explore the visa revocation debate. After that, we will compare do's and don'ts and walk through timelines and responsibilities. We will also cover edge cases and tips, followed by a couple of quick quizzes, key takeaways, and finally, a disclaimer. Legally, divorce ends the dependency tie that is the only basis for F-2 eligibility. An F-2 visa stamp is not a standalone right to enter. It is contingent on both a valid marital relationship and the F-1 principal maintaining status. Consequently, once the divorce is finalized, the dependent spouse is no longer eligible to use that F-2 visa to enter the United States. Here is the immediate impact. A visa stamp does not guarantee entry. It only reflects the possibility of entry if the underlying relationship and status still exist. After divorce, the dependency basis disappears. Therefore, any attempt by the former spouse to enter using an F-2 visa would be considered misrepresentation and could lead to denial at the port of entry and serious long-term immigration consequences for them. Meanwhile, your responsibility as the F-1 is to promptly report the change and ensure the F-2 SEVIS record is terminated. Your most critical action is to notify your designated school official immediately. Provide the final divorce decree as documentary evidence. The DSO will update SEVIS and terminate the F-2 dependence record. This is mandatory compliance. Be sure to keep a record of your email, submission, any forms, and the date and time of your contact. Failure to report promptly can become a serious violation of your F-1 responsibilities and may jeopardize your own status. Acting quickly protects you from any allegation of misrepresentation or non-compliance. To notify your DSO effectively, first send an email with a clear, urgent subject line noting the divorce and the need to terminate the F-2 record. Attach the finalized divorce decree, include your full name, SEVIS ID, program details, and the dependent's identifying information if you have it. Ask for written confirmation that termination in SEVIS has been completed. Finally, archive all correspondence and confirmation messages for your records. This will create a defensible paper trail if questions arise in the future. This sequence diagram will illustrate the information flow. The F-1 student notifies the DSO. The DSO updates the SEVIS record, which then notifies the Department of State Systems. Even if the physical visa stamp remains in the passport, DOS and downstream systems reflect that the visa is electronically invalid. If the ex-spouse attempts to travel, airline and CBP systems detect the invalid status. As a result, boarding may be denied or entry refused. Importantly, the F-1 student's primary legal obligation ends after promptly notifying the DSO and ensuring SEVIS termination, while retaining documentation. There is often debate about whether the F-1 student should contact the consulate to revoke the physical visa. In practice, once the DSO terminates the F-2 record in SEVIS, the Department of State is notified, and the visa becomes electronically invalid, even if the physical foil remains. Therefore, contacting the consulate is often redundant. Your core obligation is to ensure SEVIS is updated immediately. Any attempt by the former spouse to use the defunct visa would be their violation, not yours, provided you acted promptly and documented the SEVIS termination. On the do side, inform your DSO immediately. Provide the final divorce decree. Request written confirmation of SEVIS termination, and maintain thorough records. On the don't side, do not assume the visa stamp guarantees entry, do not delay notifying your DSO, do not provide incomplete evidence, and do not advise or encourage the ex-spouse to travel using the F-2 visa after divorce. This table organizes events, responsible parties, timelines, and risks. After the divorce is finalized, the F-1 student should act immediately. The notification to the DSO should be done without delay. The DSO will then terminate the F-2 record in SEVIS upon receiving proper documentation. If the ex-spouse attempts to travel, the consequence is likely denial of entry and potential fraud findings. Acting quickly minimizes risks of non-compliance and protects your status. Quiz time. Question: after a divorce, can an F-2 spouse who never entered the United States use their F-2 visa to enter the country? Options are A, yes if the visa stamp is still valid by date, B, yes if the F-1 student gives permission, C, no because the dependency basis no longer exists, D, yes if they explain at the airport. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. After divorce, the dependency basis for F-2 no longer exists, so the visa cannot be used. The physical visa foil's printed dates do not control when the underlying eligibility is gone. Second quiz. Question: should the F-1 holder proactively contact the consulate to revoke the F-2 visa after SEVIS termination? Options are A, always required, B, sometimes helpful but often redundant after CV update, C, never allowed, D, only if the ex-spouse requests it. You may pause the video now to consider. We will reveal the answer in the next section. The correct answer is B. Once SEVIS is updated, the Department of State is notified and the visa is electronically invalid. Contacting the consulate may be redundant, though it is not prohibited. Your principal obligation is timely SEVIS compliance. Here are the key takeaways. Divorce immediately severs F-2 eligibility. The visa stamp alone is not a guarantee of entry. Notify your DSO immediately with the final divorce decree. SEVIS termination protects your F-1 status. Contact with the consulate is typically redundant once SEVIS is updated. Finally, document each step and keep confirmations. Consider these edge cases and tips. If you suspect the ex-spouse might travel imminently, alert your DSO to expedite the SEVIS update. If the ex-spouse travels anyway, airline and CBP systems will likely flag the invalid F-2, leading to denied boarding or entry. Maintain a dated timeline that includes the divorce finalization, your first message to the DSO, and the SEVIS termination confirmation. If you have unusual facts or uncertainties, consult a qualified immigration attorney. We also provided a brief markdown-style checklist summarizing the action, proof, and outcome. Disclaimer: this content is for general educational purposes only and is not legal advice. Immigration regulations and agency practices can change, and individual circumstances vary. You should consult your DSO and, where appropriate, a licensed immigration attorney to obtain guidance tailored to your facts. To summarize, divorce immediately ends F-2 eligibility. Act quickly by notifying your DSO and providing the final divorce decree. SEVIS termination is the crucial compliance step. An electronic invalidation follows, regardless of what the physical visa stamp shows. Maintain complete documentation to protect your student status. Thank you for watching. If this video clarified your questions, please like, share, and subscribe. Let us know your thoughts and remaining questions in the comments so we can cover them in future videos.